Good afternoon and welcome to this PROPcast, which is our Eversheds Sutherland monthly client training session on real estate issues. Today's topic is options, preemptions and ROFOs. Some housekeeping before we start. The session is being recorded. I've put everybody on mute so we don't get the background noise, but that doesn't mean I don't want to hear from you. You're very welcome just to drop me a message, just picking out my name, Caroline Andresia, or sending it to everyone if you would like to share. But everybody's on mute, but please feel free to raise comments and questions as you go through. I will pick up questions possibly as we go through the session. If I don't pick it up, depending on where we are at the time, then I will stay on at the end to answer questions that have been raised that I haven't yet addressed, or to pick up any questions that might occur to you at the end. So if you raise a comment or question, it will get dealt with, maybe just not there and then. Okay, so today's topic, as I say, is options, preemptions and ROFOs. The really good thing about doing these PROPcasts month by month and just releasing the topic just in a month in advance is that we can respond to issues that we are seeing raised more often. So there has been a flurry of these options, preemptions and ROFOs that have caused complications and considerations and concerns. So I thought it was a good opportunity to discuss them, for mutual lawyer-client benefit. So we're looking at options, preemptions and rights of first offer, which I'll refer to as ROFOs. And as I mentioned, they're becoming more common. So let's just set the scene and consider the context of them in the first place. Okay, so let's just click through to the next slide. The context of it all. We are looking at these things between landlord and tenant. So just to set the scenario, it is an option granted by a landlord to a tenant, a call option, so that the tenant can require the landlord to grant him a lease of additional space. We're not here looking at an option to renew an existing lease of existing premises. We looked at options to renew leases in a previous episode of a PROPcast, which you can download and listen to again. But in this context, we're talking about a call option in the tenant's favour in respect of additional premises. For a preemption right, it's also one for a tenant in favour against its landlord to call for the right to call for extra space. Perhaps when the landlord first goes to market, you have the right to have first dibs on that extra floor in your building, say, or to match an offer that another prospective tenant has made. That's what we're talking about on a preemption front. And a right of first offer, which is simply the right to be brought to the table, perhaps to give you information about what space is available or when space becomes free, and then to be the first in conversation and negotiation with your landlord. So in a landlord and tenant scenario we're considering, but I'm not talking about, say, a landlord's preemption right to require a tenant to surrender a lease when they're looking to assign a lease, which is quite common in the in the retail situation, and nor am I talking about an option to renew existing lease of an existing premises. So that's the context that we're talking about between a landlord and a tenant in the tenant's favour. They are, as I mentioned, becoming increasingly common and unfortunately increasingly confused. There is a difference between an option, a preemption and a ROFO. They give different rights, lead to different complications, and I think are often the subject of an extra incentive to get a letting to a tenant over the line. We see a lot of just one-liners in heads of terms to say that the tenant will have a right of first offer over this floor or a right of preemption over those several floors, something like that. And sometimes then an extra incentive without much further thought. They definitely have their uses. I'm not saying that they're not always worth the bother. They definitely have their uses. They are a way for a client to anticipate future occupational needs. If you're a tenant and at the moment you want 2 floors, but actually you're hoping you could take a third because you don't want to have to move everybody to yet another building yet again. So certainly they are good for accommodating growth in the short to medium term perhaps, and also a way to perhaps postpone expense. So actually you definitely need 1 floor now. Maybe you'll need an extra half in 6 months' time. So why load yourself up with an extra 6 months of rent when maybe you could effectively draw down extra space in just 6 months' time? And they definitely are an added extra to a commercial deal that a landlord could put in favour of a tenant. But what I'm keen to get across to everybody is that we don't underestimate the potential significance of the rights granted, or the complexity of the rights granted, and the additional negotiation, drafting, and costs that coming to a landing on these issues will actually need. I think quite often we have landlord, tenant, and lawyer all understanding something different by what they think has been agreed, and it's perhaps several false starts in the drafting that then lead to actually a bottoming out on what really has been decided and what either party is prepared to give. So setting that context, I'm going to look at the issues to consider and then some of the complications that arise. So if we look at the issues to consider, these are the kind of things that you are going to need to agree as either a landlord or a tenant when entering into an option, a preemption, or a ROFO. It's very granular in its detail, but actually you don't get to a landing on what has been agreed unless you get into the detail. The devil really is in the preciseness of it. And your lawyers are going to need that detail to be able to draft effectively and without too many of these false starts I mentioned before. Often we get something drafted beautifully that turns out not to be what has been agreed. So if we are thinking of the instructions that have to be given, these are the kind of agreements that you're going to have to reach with your landlord or respective tenant in the first place. So if we start at the very beginning, the first question, who is to benefit? That might seem a bit noddy. Well, of course, that's me, as the tenant. But actually, is it just that tenant, or is it that tenant and any successors entitled to that space and to that lease? I think for an option and preemption, and a ROFO, they very generally are personal to a particular named tenant, but actually there is the potential for all of them to run to successors entitled. If the drafting is contained within the lease itself, so your lease of your first floor also includes an option, preemption, or ROFO in respect of additional premises, then under the Landlord and Tenant Covenants Act 95, then those rights and obligations will follow forward to successor landlords and to successors to the tenant. So if we mean it to just be personal to one particular person, then actually it has to expressly be said so to be. Just occasionally too, you get them to see personal to just a particular landlord, which is unusual and often not acceptable to a tenant, but may possibly be, for instance, in a scenario where we have a landlord who is doing first lets of a brand new building, and he as developer landlord is prepared to make these commitments to his first tenants, but actually once the building has been fully let and he looks to sell it on to an institutional investor landlord who's simply buying perhaps the income, then maybe that successor landlord wouldn't be bound by the same administrative complications and obligations that complying with an option, a preemption, or a ROFO give rise to. If you're a tenant too, it may be that you want this option, preemption, and ROFO to benefit your group companies. You might acknowledge that really it's just for you as a commercial entity that is to benefit, but you might want to build in some flexibility as to how you hold your property interests in the future. You may split between an OPCO and a PROPco, for instance, and you don't want to leave this precious right, with a company that actually isn't going to take the second lease. So you might want that extended to group companies. So there's even quite a lot to think about in the first place. There's just who is to benefit from the right. Then we have to think about how long this right is going to last. Of course, from a landlord's point of view, if he gives one tenant a right of first refusal or an option to call for a lease, he might be tying up floors that he then can't let to other people. If you have a call option over an empty floor in favour of a tenant on the floor above, you're going to really struggle as a landlord to find somebody else who'd take a lease at that empty floor, given that that lease would have to have probably a landlord's break right in it to allow the landlord to be able to comply with its commitment to give the space to somebody else. So you have to think long and hard about how long that right is going to last, because it may have a knock-on effect, leaving you with empty floors and lost income. But of course, from a tenant, how long that right is to last, this is some flexibility in your accommodation needs, and the right is not going to be worth anything if it's not there when you need it. Conversely, the tenant probably wants the right to last as long as possible. So we go from extremes to say that the right lasts for the whole term of the lease, that the option over other land, or the preemption right, or the ROFO lasts for the whole term of the lease. Or sometimes they have a starting point and an end point at some point in the future. So these rights don't arise, for instance, until, say, a tenant on another floor exercises its break right, or doesn't renew its contracted out lease, or vacates property. So actually there's a different future starting point to the right, not throughout the whole term. And then too, they might end in certain ways. For instance, a landlord might say, well, yes, this is an extra added incentive to you, this particularly prestigious trophy tenant that I want to entice into my building. But actually, if you're no longer in occupation, or if you're no longer trading as that snazzy retail brand, I don't think you should have the right to take extra space. So they might start in the future, but also might stop at some end point too. So there's really quite a lot of detailed instructions that's needed on simple things like who is to benefit and how long the right is to last. And then there are sometimes triggers to the right. So we've talked before when we were thinking about options to renew leases on present premises as to whether that option would be conditional. And there's often conditionality built into an option to take additional premises, because a landlord will say, actually, why would I want a poorly performing tenant on yet another floor? You've at least got to pay your rent up to date, or you've got to be compliant with your covenants. But then, if you're a tenant who has reached a commercial agreement with a landlord to get this extra right, you might be thinking, well, actually, you landlord have alternative remedies for breach of covenant, just suing me, for instance, and why should I lose what is a very precious commercial benefit to me, simply perhaps because of some genuine dispute over service charge arrears, something like that. So there can be triggers to the exercise of the right and some inherent conflict around that conditionality of it. For a preemption right, obviously the trigger might be the landlord going to market, or the trigger might be the landlord actually agreeing a deal for the next floor down with an alternative tenant. So that can be a trigger that can come out of the blue when the landlord just decides to market, or at the point when the landlord has actually landed a deal with somebody else. And then something like a right of first offer, we've seen all sorts of different triggers. Lately we've seen things like, as I mentioned, when the fifth floor of the building becomes available to let on the open market, for instance, when the tenant of the fifth floor serves a break notice, when practical completion of some refurb of additional space takes place. And some we've even seen as extreme as if and when the landlord builds another office building on this development. So, the ROFOs can have a huge range of options that start them. And especially with the ROFOs, there's sometimes a tenant trigger. There is a mechanism built into the lease by which the tenant serves notice on the landlord saying, right, I need extra space, please tell me if you have any available in this building or when any space in this building becomes available. And that then triggers that obligation on the landlord to keep the tenant informed and to invite the tenant to make first offer. And then when we've looked at who is to benefit, how long that benefit is to last, what starts that benefit running, we also need to think about the space of it all. Which floors are to be included? What space? Is there a minimum size of space that triggers the right? How important is, say, for a tenant to have contiguous floors? I mean, a tenant who has the 6th and 7th floor might not be interested when the 15th floor becomes available, or a tenant who's got floors 5 and 7 will actually want to be very sure that it gets first dibs if floor 6 becomes free. So considerations right from the beginning, a lot of detail, and just those 3 questions. And moving on to the kind of considerations we need, how is that right to be exercised? And the key issue here that I'd like to stress is it's all in the timing, because all 3 mechanisms, options, preemptions and ROFOs, add potential delays to lettings for landlords. And of course, empty space means lost income. And there's nothing to say that the right of first offer that your tenants have will lead to an offer that you're happy to accept. So you might have built-in delays that leaves you unable to negotiate on the open market with other prospective tenants, but still leaves you empty-handed. The time it can take to put together an offer, the time it takes to perhaps determine a market rent, if that's what you're going for again, all of that timeline in total can add up. So if it's sort of X weeks to serve notice, Y weeks to serve a counter notice, X weeks to come to an agreement, Y weeks to refer to expert determination, that could give you quite a long period of time. But it might take a tenant quite a long time to come to a conclusion as to whether it wants that space right now, or whether actually it'll take that space even if it doesn't quite need it because it's going to need somewhere next year, for instance. So I would suggest always looking at that timeline in total to see if it's something that both sides can live with, and then actually recalculating, reanalyzing that timeline once the document has actually been agreed, because time periods move in negotiation and sometimes can end up inconveniently car crashing into each other or overlapping. So I think a very good thing to do is to reanalyze that timeline at the time you're about to sign the document. And then when we've thought about who and when and what and how and all that kind of thing, what are the terms on which that right is to be exercised? Effectively, is it the same again? Is it just a lease this time of the 5th floor in the same way you've got a lease of the 6th floor? Or actually is there going to be some wriggle room, some room for manoeuvre and negotiation when you come to take that extra space? Obviously, a right of first offer involves just that. You can put terms forward whatever you like, but presumably you would use the terms of your existing lease to give you sort of some kind of educated guess as to what offer the landlord would accept going forward. But say for an optional preemption, are you going to get a lease of additional space on just the same rent as you're paying for your one floor at the moment, or it will be now the open market rent for that additional space, or perhaps your existing rent on a square foot basis but subject to some kind of indexation in line with RPI? And then, do you want your lease terms to stay the same? Is it appropriate for the tenant to have the same terms if they're taking more space? Would perhaps a tenant like more control of the building if actually, having taken floors 1 through to 7, they finally land floor 8 and are now the tenant of the whole building? It might be that the tenant would want to manage the whole building from that point going forward. It might be the landlord might want to offload the whole business's provision of services and what have you. So the terms of both leases might need to change going forward. Side agreements, for instance, that's something we discussed when we were talking about options to renew existing leases of existing premises. Do you want to repeat those side agreements? If you've negotiated with your landlord to be able to bring your dog to work on the 6th floor, presumably you'll want to bring your dog to work on the 5th floor. So it may not just be the lease that you're putting in place again for the extra space, but also the side agreements. Then there's some more subtle changes that might be made to the new deal, so it's not the same exactly as your lease above. Should the terms perhaps of the rent review be changed to disregard your occupation not just of the premises, but of other floors within the building? If you've now got a greater floor area of the building, should your service charge weighting change? Should you get a discount because you've now got more floor? And most importantly, perhaps, what should the term of the new lease of the new floor be? I would expect most tenants would want all leases to end coterminously, or maybe not. Maybe you think that actually this building is a stepping stone to something much bigger, and you'll move out of this building in sections, and so you're quite happy to have one lease of one floor run on beyond the floor of the other. But if you want the two leases to end on the same date, are you then going to get, say, 10 years from when the first lease was entered into, so your lease of the next floor might be sort of 8 years and 6 months, or actually do you want your second lease of your new floor to be for the whole 10 years, to get your money's worth, say, out of the fit out and the location and what have you, in which case do you want a reversionary lease of your first lease to be added to your extra floor so that you get those extra months for your floor above? So even the very term of the lease you're getting in return needs to be thought about. And then when you've exercised the right, does it fall away? Is this a once and for all job, which might be entirely relevant if it just relates to one particular identified floor, but if it's a right of first offer whenever space becomes available, is it just one shot and then falls away if you don't or do take the extra space and your offer is accepted or not, or actually does the right continue? So to be able to draft just what we need to draft to make it match just what you need to agree we're going to need instructions on all that nitty-gritty. So once you've got your head around all the information that you have to give us, I'm now going to just have a stop and look at some of the complications that we are seeing arise. It seems impossible that once we have been given all the information about who gets the benefit, how long it's going to last, how we exercise it, what are the terms it's going to be, and we've done that real granular drafting, that actually things can still go a bit pear-shaped. So looking at the complications of it all, firstly, number one, and this is a bit of a plea from a professional support lawyer's heart, is that over-engineering. Because when things get very difficult, the lawyers bring things to me. When we're all trying to get something to agreed, then often I'm brought in as a sort of second pair of eyes and second opinion, and the over-engineering can be really tricky. So I'll give you just as an example, one we have presently, where we have a tenant who has taken a floor in a building. Great, we like to attract a good tenant to a good building. So they have one floor. They have then been granted an option for 1 year, for 12 months, to take the floor below. Either it's in entirety, or in two halves, or just one half first and then the other half second. Okay, so they have got an option for 12 months of the floor below, which effectively means the landlord can't let that floor below to anybody else for the next 12 months, because nobody's going to take it with the thought that they might have to move out again in 12 months' time. But then they might be left with half a floor, because the tenant above actually has just exercised their call option in respect of half a floor. Or they might take half a floor and then a bit later take the other half of the floor. So that fate of that second floor below is very unknown. And then to add to that tenant's 1 year option, at the point the option expires, they've then got a first 18 months right of preemption on that floor below, but this time in quarters. Yeah, not halves or whole, but in quarters. So that if the landlord finds another prospective tenant or finished the work on the floor below during that course of 18 months, he's got to first offer it to the tenant above, who can then preempt and take that lease in quarters. But could take it in 1 quarter or 4 quarters, and that's a very complicated mashing of both an option and a preemption, which makes for very extensive and complicated drafting. And another one we've seen recently, for instance, it gets into the complete hypothetical. You might have the possibility of if I decide to redevelop, and then if I, landlord, decide to redevelop, and if this redevelopment actually forms a retail and leisure redevelopment, and then if it is a retail and leisure redevelopment and I build a cinema, and if it's a retail and leisure development and I build a cinema, and it's a multi-screen cinema, then I will give you a particular cinema operator a right of first offer. Now, that is a long way down the line. It's not the kind of thing you build on spec, presumably, at a multiplex cinema. You don't sort of build one and then just wait for someone to come along to take it. So that kind of drafting is going to be very difficult to handle too. And is it going to get both parties what they want? It's not going to get a guaranteed tenant. It's not going to get guaranteed space. So there is an element of over-engineering that we need to take into account. Nuances of drafting. This is perhaps one more for our real estate litigators, but you get into conversations that are really, angels dancing on pinhead kind of conversations when you think about the difference between vacant and available for letting, available for letting on the open market, for instance. And all three of those things might mean different things in context. Available for letting on the open market probably wouldn't be the case if another tenant in the building had an optional pre-emption or ROFO in respect of that actually you can't take it to the open market yet because you've got people in the building, not on the open market, who need to be offered to the premises first. So even just those three phrases have very different kind of meanings. And then I have a slight concern about the sharing of information. I think if you're a landlord who's entered into one of these agreements, there might be quite a lot of commercially sensitive information that you are obliged to share with a tenant. If you have to tell them when there's going to be space available, that might well be commercially sensitive information that leads to the value of your building being known, for instance. Do you have to tell the tenant then that your biggest other tenant will be moving out? Or do you have to share with them the information that somebody served a break right? Do you then have to update them as to whether the conditions attached to that break right have been satisfied? Do you have to tell people that a particular tenant has exercised its contractual right to renew, or served a Section 26 request for a new lease under the 1954 Act. So that's a lot of sharing of information that normally landlords might not want to be made public, but in these kind of situations might be obliged to disclose. And just a few more complications: competition between tenants with similar rights. As I mentioned, actually a property is not available perhaps for letting on the open market if somebody else has a tenant, has a right over it, another tenant has a right over it. And some of the biggest complications we've seen is where one tenant has an option, somebody else has a preemption, and three of them have a ROFO. There must be some kind of pecking order to these tenants if they have rights over similar space, or perhaps just over any empty space that becomes available. And then you would have to work out which tenant takes priority to which, and perhaps first offer it to one and tell them there's space available. Do they want to exercise their call option? Give them 30 days to do that, perhaps give them time under the option agreement to try and agree a market rent, and then if that fails, you then perhaps got to offer it to someone you've got a preemption right in favour of, and then possibly lastly someone has a right of first offer that perhaps trounces all that. So some of the tricky situations we have come across is where there's competition between tenants with similar rights. And then heaven help us when we're considering its interrelationship with rights of security of tenure under the 54 Act. And heaven help us if any of these leases of additional premises are to be contracted out of those security of tenure rights, because then we'll have to think about how the warning notice from the landlord is going to be served, at what point the tenant is going to swear the stat dec, and the whole timing of that process, which of course can't be gone through until the demise has been correctly identified and the terms of the lease have been agreed. So, which quarter of the floor are they going to take? What is the open market rent going to be? Does that new lease need some changes to the drafting to reflect the fact that now tenant of more one floors? Only then could we do the 54 Act contracting out process. So the interrelationship between these rights and the 54 Act really needs consideration too. And then lastly, it's very tempting to put in overriding good faith obligations as a kind of panacea in the drafting. But good faith obligations often have unintended consequences through its generality that I think we need to be aware of. So for instance, if a landlord has a good faith obligation towards a tenant who wants to take extra space, is that landlord under any kind of obligation to perhaps waive the conditions to a break right that might not be fulfilled? Or perhaps if they have a tenant who's holding over under the 54 Act, is a landlord under an obligation, because of its good faith clause and obligations, to perhaps serve a Section 25 notice on that holding over tenant, to make them make a decision, to possibly prompt them to move out, to make some premises available for letting on the open market. So I am cautious about putting in generalist good faith obligations. I think that needs considering. So really, in conclusion to all of this, my appeal would be that actually to think very hard about the terms to be negotiated, think very hard to make sure that you as landlord and tenant are both in agreement and actually understand what each of you mean by what you have put forward. When you're a tenant, think about how likely the space that you want is going to become available. Is all this just too hypothetical? Is this might be something offered by your landlord that really you're never going to have use for? And as to whether actually it should make a difference to your decision whether or not to take premises. And then if you're a landlord offering a group of tenants, different tenants on different floors, sequential rights or overlapping rights, be aware of the very long process you might be walking into before premises can become available to let, and the sheer technical nature of the advice you might need to stay on the right side of all that advice. So really, in conclusion, it would be to consider your commercials very carefully and your legals even more so. Right, as I mentioned, I will keep the call and the webinar open for a moment or two in case anybody has any questions. As I mentioned, the session has been recorded and will be available on the PROPcast page on our Eversheds Sutherland website in a week or two. If you have any feedback on the session, then I'm very happy to receive it either by email or just now through the chat function. Or if you'd like to make requests for topics for further PROPcasts or for your particular team's training, then that's just fine. I'm always happy to take requests. So as I said, I will stay on the call and the webinar for a moment or two to pick up any outstanding questions. Otherwise, it just remains for me to say thank you very much for attending, and we hope that you found the session useful.